Hi everyone, my name is Chandan and I welcome you all to this platform of Utilitarian IAS इंडियन पॉलिटी की 2000 MCQ की सीरीज में मैं आपका स्वागत करता हूं. फाइनली वी हैव क्रॉस दिस माइलस्टोन ऑफ 1200 क्वेश्चंस. टुडे वी विल बी स्टार्टिंग फ्रॉम 1201. दिस इज गोइंग टू बी टेस्ट नंबर 61. दिस इज अ स्टैंडर्ड टेम्पलेट दैट वी हैव बीन यूजिंग अक्रॉस द ऑल वीडियोज. Now we are starting first question of the day, and that is consider the following statement regarding precedent rule. Article 356 you would be knowing. Precedent rule is imposed when government of state cannot be carried on in accordance with the provision of the constitution. That is what the premise of article 356, right? 356 को ऐसे ही आप impose नहीं कर सकते. There has to be premise, and premise is this, and this has been mentioned into the constitution. So that's correct statement. The governor sends a report in this regard to the center, which forms the basis for invoking article 35. No, article 35 is part of fundamental right. We are here talking about precedent rule जो है वो invoke होता है by invoking article 356 of the constitution, right? Once precedent rule is imposed, the assembly ceases to function and the state comes under central government's direction. So that is a correct. The assembly cannot be kept in suspended animation. That's incorrect. Assembly can be kept in suspended animation at least for the period when the Supreme Court or the Parliament has not approved this article, operationalization of article 356. Until then जो ये है assembly है, that will be kept into the suspension mode. So what are the statement correct has been asked. So what are the statement that are correct? That you can see 1 and 3, that is going to be correct statement, hence B is going to be the right answer. Consider the following statement with reference to preamble. The preamble explains the objective of the constitution. True, very true. The preamble cannot be amended. Come on, this can be amended, right? This has been amended once at least, right? In 1976 by 42nd constitutional amendment, by introducing 3 words. You would be knowing what are those 3 words. Social, secular and integrity, right? Preamble explains the ideals to be achieved in independent India. That's correct. The preamble was first section under the constitutional scheme to be drafted, and no, it was the last scheme actually, right? Preamble, although पहला पन्ना जो है first page of the constitution is preamble, but surprisingly it was the last thing to be debated, drafted and enacted. ठीक है, again incorrect statement has been asked. So you have fourth statement and second statement is incorrect, and that's why A is going to be the right answer. Consider the following statement with regards to fundamental right. Fundamental right are not absolute in nature. That's completely correct, है ना? That can be amended, and that's why it can be called absolute. All rights under article 14, 16 and 21 are enjoyed by foreign citizens also. No, article 14 yes, article 21 yes, these two rights can be enjoyed by foreign citizens as well. But when it comes to right to public employment, right, that can be guaranteed only to the citizens of India, right, not to the foreigner. So that's incorrect. These rights are available against the arbitrary action of the state as well as private individuals. So that's correct, है ना? सिर्फ स्टेट के अगेंस्ट देयर आर सर्टन फंडामेंटल राइट विच आर अवेलेबल अगेंस्ट प्राइवेट इंडिविजुअल एज वेल. करेक्ट स्टेटमेंट हैज बीन आस्क्ड. सो 1 and 3 is going to be the correct statement. Consider the following statement with regards to DPSP. The DPSP mandate includes the establishment of social and economic equality for the collective. That's correct, है ना? फंडामेंटल राइट आपका पॉलिटिकल इक्वालिटी को प्रमोट करता है, और ये जो है सोशल एंड इकोनॉमिक इक्वालिटी को. The directive principle are in nature of instrument of instruction to both political and permanent executive. That's correct. Courts are not competent to compel the government to carry out the DPSP. However, the court can declare the law void if it contravenes any of the directive. That's incorrect. First segment इसका correct था, but second segment जो है third statement का that's incorrect. Courts cannot declare any law void because justiciable नहीं है ना. DPSP, if it would have been justiciable, then if any of the law passed either by the state legislature or parliament, if it would have violated DPSP, spirit of the DPSP, then court could have declared that law void. But because it is unjusticiable, so courts cannot do that, right? So correct statement has been asked. First and second is going to be correct statement. A is going. Consider the following statement with respect to the principles of rule of law. Again, incorrect statement has been asked. The concept of equality before law is an element of concept of rule of law. That's correct. The rule of law ensures absence of arbitrary power, that is no man can be punished except for the breach of law. That's correct. sorry, the Constitution of India is a result of right of individual. No, the very first segment of this statement is incorrect. The Constitution of India is not, ठीक है, अमेरिका में है कि भाई Constitution of USA is actually result of rights of individual, but यहाँ Constitution rights देता है, ना कि rights की वजह से Constitution है ना। अगर आप लोगों ने इंडियन पॉलिटी को डिटेल में पढ़ा है तो इस लाइन को आप लोग समझ जाओगे, अगर नहीं डिटेल में पढ़ा है तो आप लोग नहीं समझ पाओगे। दैट्स इनकरेक्ट। Incorrect पूछा, so third only is going to be incorrect. Which of the following titles is or are allowed under Article 18? Knighthood? No, it can't be awarded. Talukdar, Jamindar, these are all illegal and it has been abolished. Article 18 का violation होगा अगर state इन तरह के award. But Bharat Ratna, come on, Bharat Ratna and those 3 civilian other awards, ठीक है, those are allowed under Article 18. Awarding of those awards, right, by government of India, that will not be considered violation of Article 18. So disallowed, right? So disallowed, first is disallowed, third and fourth is disallowed. First 3, 4. C is going to be the right statement. Which of the following statement is are correct with respect to writs? Okay, only Supreme Court has been empowered to issue the writ jurisdiction, empowered with the writ jurisdiction. No. Sorry, High Court also under Article 226 High Court is also empowered. हमें करेक्ट बताना है, ठीक है। वन को एक बार एलिमिनेट करें, दिस कैंट बी आंसर, दिस कैंट बी आंसर, सो आइदर दिस इज आंसर और दिस इज आंसर, है ना। सो देखना है सेकेंड स्टेटमेंट, पार्लियामेंट बाय लॉ कैन एक्सटेंड पावर टू इशू रिट्स टू एनी अदर कोर्ट, सो दैट्स करेक्ट एंड सेकेंड इज गोइंग, पहले ही आंसर आपका रिफ्लेक्ट हो गया। द रिट सिस्टम हैज बीन adopted from US president? No, that's incorrect. Writs are extra constitutional rights given to the judiciary by the no, it's a completely constitutional right, Article 32 and Article 226, so only second statement is going to be correct and C is the right answer. Which of the following government initiative is our fulfilling objective of DPSP of the state? Abolition of private purses? Yes, that is fulfilling actually by promoting equality. Deletion of right to property from fundamental right to reduce economic, so yes, अगर right to property होती तो बहुत सारे जो जमींदार वगैरह हैं उनके पास बहुत सारी प्रॉपर्टीज होती, और जो DPSP के ऑब्जेक्टिव है इकोनॉमिक पैरिटी लाने का, वो फुलफिल फॉलोइंग द प्रिंसिपल ऑफ न्यूक्लियर डिसआर्मामेंट, ये भी ऑब्जेक्टिव आपका फुलफिल करता है DPSP का। एनकरेजमेंट ऑफ खादी ग्राम उद्योग, सो अगेन दिस आल्सो फुलफिल्स the purpose of what you call DPSP, ठीक है। So 1, 2, 3, 4 all are going to be the part of answer. Which of the following articles of the Indian Constitution reveals the secular character of the Indian state? Article 15 as well, discrimination on grounds of religion को रोकता है। Article 16 public matters में state को अलाउड नहीं है कि religious grounds पे discrimination कर सके। Article 29 and Article 14 EBL and EPL, equality before law irrespective of religion, race, ये सब चीज़ें, है ना। एंड आर्टिकल 29 एज वेल सिमिलरली कल्चरल एंड एजुकेशनल राइट्स को प्रमोट करता है। सो ऑल दीज 4 आर्टिकल्स दैट आर गिवन हियर प्रमोट्स और रिवील्स एक्चुअली द सेक्युलर कैरेक्टर ऑफ इंडियन स्टेट, सो डी इज गोइंग टू बी द राइट आंसर। कंसिडर द फॉलोइंग स्टेटमेंट विद रिस्पेक्ट टू स्कोप ऑफ जुडिशियल रिव्यू इनटू द प्रेसिडेंट रूल। द satisfaction of president in invoking Article 356 is final and conclusive and cannot be challenged in any court. That's incorrect. It can be challenged on the grounds of mala fide, है ना, it can be challenged. The satisfaction of president must be based on relevant material, of course, that's correct. Correct पूछा, second one is going to be the correct statement. Which of the following are exception to the principles of single citizenship? ठीक है, the parliament under Article 16 can prescribe residence as the condition within a state or union territory as a condition for certain, that's correct, and this again is exception to the principles of single citizenship, ठीक है। citizenship के basis पे आप employment दे रहे हो, so this is the exception, so that's correct. A state may offer concession in fee for the education to its resident as it does not violate, so that's correct. The right of outsider to enter, ये सब fundamental आपके rights के part है, and this goes against, or this is actually exception to the principles of citizenship. तो करेक्ट स्टेटमेंट पूछा है, सो ऑल थ्री आर एक्चुअली एक्सेप्शंस टू द प्रिंसिपल्स ऑफ सिटीजनशिप. ओके, मैंडेमस इज अ कमांड इशूड बाय द कोर्ट टू अ पब्लिक ऑफिशियल आस्किंग हिम टू परफॉर्म हिज ड्यूटी, ऑफिशियल ड्यूटी दैट ही हैज फेल्ड और रिफ्यूज टू परफॉर्म अगेंस्ट विच ऑफ द फॉलोइंग रिट कैन नॉट बी इशूड. सो मैंडेमस एक्चुअली पूछा गया कि मैंडेमस की डेफिनेशन दी है एंड मैंडेमस किस किस के अगेंस्ट इशू नहीं किया. सो अगेंस्ट प्राइवेट इंडिविजुअल लिंक टू द ट्रिपल पी, यस मैंडेमस कैन नॉट बी इशूड. ठीक है, कोर्ट्स को, इंफीरियर कोर्ट्स को, गवर्नमेंट्स को, ठीक है, इनको इशू किया जा सकता है, बट जुडिशरी को, ठीक है, प्रेसिडेंट को, गवर्नर को, प्राइवेट इंडिविजुअल्स को, दीज पीपल उनको कॉन्ट्रेक्चुअल ऑब्लिगेशन को फुलफिल करने के लिए, है ना, मैंडेमस इशू नहीं किया. अगेंस्ट द चीफ जस्टिस, यस इट कैंट बी इशूड. अगेंस्ट द प्रेसिडेंट ऑफ इंडिया, आई ऑलरेडी टोल्ड यू, अगेंस्ट प्रेसिडेंट एंड गवर्नर इट कैंट बी इशूड. सो ऑल दीज थ्री आर गोइंग टू बी द करेक्ट स्टेटमेंट. मैंडेमस इन तीनों के अगेंस्ट नहीं इशू किया जा सकता. कंसीडर द फॉलोइंग स्टेटमेंट विद रिस्पेक्ट टू एक्ट ऑफ गुड गवर्नमेंट ऑफ इंडिया. एक्ट ऑफ गुड गवर्नमेंट दैट इज 1858, है ना. द एक्ट अबॉलिश्ड ईस्ट इंडिया कंपनी एंड ट्रांसफर द पावर्स of the government territories and revenue to the British Crown. That's correct. It extended the system of double government by abolishing board of control and court of director. That's again correct. It created new office of viceroy who was a member of British cabinet. No, actually जो member of British cabinet, it was secretary of state and not the viceroy. Although the office of viceroy had been created, but it was already existing. जो governor general of India है, उनको बोला गया कि now onwards you will be wearing two hats, one of governor general of India when you are in administrative capacity and one as viceroy when you are acting as a acting on behalf of crown. ठीक है, तो viceroy, but this viceroy was not part of British cabinet, it was the secretary of state. So this is incorrect. अपने को correct बताना है. So first and second is going to be correct statement. Consider the following statement with reference to the constituent assembly. The member of constituent assembly were indirectly elected by the members of existing provinces. That's correct. The election of the member of constituent assembly from the princely state was direct. No, it was not direct. ठीक है, they were nominated. The members from the princely states were nominated by their kings. With independence of India, the constituent assembly became fully sovereign body. That's correct. Correct बताना, 1 and 3 is going to be correct. Which of the following statement states the limitation upon the enforcement of the fundamental right? State legislature shall have power to modify application. No, state legislature can't have. It is the parliament which does have power to modify the application of fundamental right. The parliament may enact a law stating certain jobs can be filled only by applicant who are domiciled into that particular area. So that's correct. Article 16 में हम लोगों ने अभी just previous to previous question में पढ़ा. Correct बताना है. So second only is going to be correct and hence B is going to be the right answer. Consider the following statement with respect to Government of India Act 1935. It provided for the establishment of Federal Public Service Commission for 2 or more provinces. That's correct. Federal Public Service Commission and JPSC के जो provisions है that were introduced in India by this Government of India Act 1930. It abolished the diarchy in provinces and introduced provincial autonomy. That's correct. It extended the principle of communal representation by providing separate electorate to depressed class women, and that's correct. It introduced for the first time bicameralism. No, for the first time bicameralism had been introduced by government, the previous act, Government of India Act 1919 and not by 1935. ठीक है, so that's incorrect. Correct बताना है. So 1, 2, 3 are going to be the correct statement. A is the right. Which of the following are the features of federal structure? Bicameralism, yes, this is a feature. This is not a unitary feature, this is a federal feature. Written constitution, yes, federal feature. Supremacy of, yes, federal feature. Single citizenship, no, this is not a federal feature. This rather gives blame to the Indian constitution of being unitary. Integrated judiciary, again this is a unitary feature and not a federal feature. ठीक है, so 1, 2, 3 are going to be the answer and here goes C is the answer. Consider the following statement with reference to constitutional importance of regulating Act of 1773. It was the first step taken by British government to control and regulate the affairs of East India Company in India. That's correct. It recognized for the first time the political and administrative functions of the company. That's correct. It made governor of Bombay and Madras presidency independent to the governor. No, independent नहीं बनाया. It made actually Governor General of Madras and Bombay presidency subordinate to the Calcutta presidency. ठीक है, so that's incorrect. It distinguished between commercial and political. No, that's actually provision of Pitt's India Act 1784. So first two statement are going to be correct, 1 and 2, hence C is going to be the right answer. Which of the following statement are correct about Constitution of India? It generates a degree of trust and coordination among people. That's correct. That is the purpose of constitution, not only of India but of across the world, right? Every countries का जो constitution बनाने का purpose है, that should be. It specifies how government will be constituted. That's correct. It lays down limits on the powers of the government. That should be again the purpose of the constitution. It provides standards to examine and evaluate any law and action. That's correct. So all four are going to be the answer. Hence D is the right answer. Which of the following features are correct with respect to India? India is a quasi-federal state. Yes, that is a blame that has been put on the India being a federal state. So that's correct. India is a union of state. That's also correct. India is a quasi-judicial state. No, it is not a quasi-judicial state. Rather, America at times, due to its strong judiciary, which is often called third pillar of American state, right? So it is due to what you call strong judiciary that America is blamed for being a quasi-judicial state and not the India. So this is not the Indian definition. 1 and 2 is going to be the right feature of India, right? So A is going to be the right answer. So with this we are wrapping up this video as well. We'll meet you into the next video. Till then, bye bye.